Good afternoon, everybody. Welcome to today's webinar presented by the Sunshine State Digital Network, Copyright for Digital Libraries. My name is Kayla Sajas-Ruiz. I'm the Program Director for the Sunshine State Digital Network, and I'll be presenting today's webinar. A few housekeeping items. We have enabled closed captioning. So if you would like to see the captions during the presentation, click on the CC button that's located on the bottom of your Zoom window. If you don't want to see captions, you can also turn them off there. This webinar is being recorded. So you will get a recording. It will also be posted to our Sunshine State Digital Network YouTube channel for on-demand viewing. And keep that in mind as well if you decide to unmute for questions. During the presentation, you won't be able to unmute yourself to ask questions, but you can place questions in the chat box and I can monitor your questions there. If you'd like to wait until the end, I will allow you to unmute yourself at the end if you would prefer to not type a question. But keep that in mind as well. Okay, and without further ado, let's get started. So just as a standard disclaimer, the first thing for this presentation is that I am not a lawyer. I am a cultural heritage professional. So this is not legal advice. It's a set of strategies for content selection and assessment. So we're dealing with the law here. Things are interpretable and squishy. Unlike death and taxes, these are not absolutes. Additionally, we will only be covering US copyright law during this presentation. Items created and published outside of the United States are subject to different laws and regulations. So that is something to keep in mind. Additionally, I will add that all of the dates that we'll be talking about today will apply beginning January 1st, 2026. So this will be starting after the end of this year. Okay, so the goals for today's presentation are to understand strategies for selecting and describing content on the basis of copyright status. So hopefully at the end of this session, you should feel confident assessing the copyright status of an item, identifying content for digitization, and creating useful rights and access metadata for those items. So we're going to do a little practice. We'll revisit all of these items once we've gone a little further and I've given you more information. But just take a note or add in the chat right now whether or not you think the following items are under copyright or if they're in the public domain. And then we will revisit them later. So for this item, it's an advertisement from 1942. And just from what you know right now, what do you think the copyright status of this item is? We have some in copyright. In copyright. Okay. So there seems to be consensus that we feel like this is protected by copyright, and we will find out later on. Okay. So for this one, we have a poster for an election for a candidate for governor from 1950. So go ahead and write down what you think the copyright status of this item is. In copyright, domain, public domain question mark. Okay. Here we have a letter from 1833. We have public domains. Okay. Also some consensus here. A cruise pamphlet from 1920. Okay. So it's not, it's pretty straightforward as well. Lots of consensus there. Okay. This item is a drawing by an artist working for the Defense Visual Information Center. We don't have a year for this one. Mixed responses on this one. And then the last item is a menu from 1964 from the New York Central Railroad. Some mixed responses for this one as well. So hopefully, when we get to these, people will have a better idea of the copyright status of some of these items. Some of you are right and some of you are wrong, and we'll find out why. So first things first is defining copyright. What does this term refer to? What are we talking about when we are talking about copyright? So when we talk about rights, we're talking about any reproduction or publication restrictions on an item. It's copyright status according to US law. In the world of digitization, we're in the business of making digital copies of physical items. This is considered reproduction. We're also in the business of displaying these items and making them public, which is a kind of publishing. So we're talking about restrictions on an item when we're talking about copyright. Copyright protects creators and publishers by ensuring that they alone can decide how to reproduce and distribute their content. This may restrict whether an item can be digitized and shared on the open web. Copyright laws are also designed to limit the term of copyright so the public would eventually have unrestricted access to the content. The history of copyright law is about balancing the protection of the creators and the public interest to access. So copyright law terms or amounts of time of protection change over the last 100 years. That has changed over time. So as we talk about some of the ins and outs of current copyright law, you'll see that we're often talking about periods of time. The length of those periods of protection for copyright owners have also changed over time. And copyright laws that have changed over time means that it's important to refresh your own knowledge of copyright from time to time. Copyright law is also designed to give the most protection to unpublished creative works of artists and other creators. So why is copyright important? It helps cultural heritage institutions determine whether or not they should digitize an item, and if they decide to digitize, what level of risk they are accepting. We'll talk later about what risk means in this context, and I know it's a source of anxiety for a lot of institutions, the amount of risk that they take on when making items that might be protected by copyright available online. Copyright isn't just important for digitizers, it's also very important for users of digital content. So knowing the copyright status of an item helps users determine what they can and cannot do with it. Can they make their own copy, add things to that copy? So it's important for you to share what you know with them so that they can use your content responsibly. So now we're going to talk about how to evaluate your content as you're selecting for digitization. I'm also going to make some practical recommendations on how to get started. So first, we need to define or ask some questions when looking at our content. So how many of these questions can you answer about the content that you're considering for digitization? Do you know who the creators are? Do you know when it was created? If it was ever published, and published again will have a very specific meaning when it comes to copyright law. So published means something a lot broader in the context of copyright than we usually think of when we think about what published means. And we'll talk about that definition in a minute. So if it was ever published, by whom? And then do you have external information about copyright restrictions, like in a deed of gift? Or can you contact the donor to find out what, if any, copyright restrictions apply to that item? So let's talk about that fourth question first. So does your deed of gift form include a provision for digitization and online reuse of donated resources? Should it? Yes, absolutely. If your deed of gift does not have this in it already, you should consider adding it as soon as you can. And if you have existing deeds of gift where you can still contact the donor, you should consider having them look over an amendment if you think that the content that they donated will eventually be digitized and made available, or you would like to do that. So a note about best practices for collecting new archival materials. When you receive a donation, be sure to ask questions upfront from donors about digitization and online display. Get the donor to make an agreement with you about what is and is not okay online during the donation process instead of trying to find donors at a later date. A deed of gift is a signed document that voluntarily and without recompense transfers ownership of real, personal, or intellectual property, such as a gift of materials from one person or institution to another. It should include any possible conditions specifying access, use, and preservation of the gift, although these are generally discouraged by recipient institutions. And the deed of gift also provides provenance information for your administrative records. So what does this permission look like? What are some examples of what this would look like? So here on the left, we have permission to digitize and display online reproductions on the internet. But this permission is limited, and the donor is not surrendering their intellectual property rights. They're only allowing you to make it available for research purposes. On the right, we have an example of where someone is assigning their intellectual property rights to the institution. So they're transferring those intellectual property rights to you. So as you begin your content selection process for digitization, you want to start by identifying content that's in the public domain. This is going to be your lowest hanging fruit, the easiest thing where you won't have to worry about risk because these items are not protected by copyright. So what is the public domain? This is when the intellectual property rights of works have expired, have been forfeited, or are inapplicable. This is when copyright law does not apply to a work. Works in the public domain may be used freely without permission or attribution. This also means that when you're making these items available online, that you also do not have intellectual property rights to these items. So people do not have to cite or attribute your institution for these items because you do not have you do not own the intellectual property rights for these items. This is a really important concept to understand about materials in the public domain. You can digitize away. You shouldn't be concerned about what risk when digitizing these materials. But again, this means that you are digitizing these items as a public service. and you do not have control or say on how those items get used or reused. So just be aware that it's not a requirement. Okay, so now we're going to walk through the different ways that items enter the public domain. So there's 5 situations that apply for items in the public domain. Number 1, the copyright has expired. Number 2, the copyright owner has published the work without a copyright notice. The copyright owner failed to renew their copyright status. The copyright owner deliberately places or dedicates it to the public domain using a Creative Commons 0 dedication, or copyright law does not protect this type of work. So we'll talk about all of these. So the first one, copyright has expired. So items published in or before 1930, again, this is of January 1st, 2026, are in the public domain. This is a rolling date as of 2019. So copyright law changed, or a certain copyright protection expired in 2019. So this allows for new items to enter the public domain this way every year. Before 2019, this was a static date, but now we get new items every year in the public domain. So next year, 2027, items published in 1931 will enter the public domain. And remember that I said published material means something very specific and a little different than we're used to when it comes to copyright. So what does that mean? To summarize, publication means distributed to the public. We generally think of publication as applying to items with publishers like books or journals, newspapers, but published according to copyright law is broader. It basically means that the item has been distributed. So publication is the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership, or by rental, lease, or lending. The offering to distribute copies or phonorecords to a group of persons for purposes of further distribution, public performance, or public display constitutes publication. A public performance or display of a work does not itself constitute publication. Generally, publication occurs on the date on which copies of the work are first distributed to the public. So what are some examples of this? So according to copyright law, publication is distribution. So things that are likely to be published under copyright law are things like books, posters, brochures, pamphlets, things like programs, or things like blank postcards, right? Because they're selling an image on the postcard, and that's distribution. Some things that are potentially unpublished are correspondence, a lot of photographs that we would have in our collections, so like personal photographs are generally not published material, and then postcards with writing. So postcards may have multiple layers of copyright on them because of the published material on one side and the correspondence on the other side. So a lot of the things that we're going to be talking about today are like things that are printed or on paper, but things like audio recordings and video recordings are also potentially going to have multi-layered copyright on them. So that's also something to consider when doing your selection for digitization, is what are the different layers and what different permissions and what other information might you need to know to understand the various layers of copyright that might apply to an item. Copyright law is designed to offer the most protection to unpublished material, especially creative materials. So looking at the top row of this chart in particular, unpublished materials like the correspondence we discussed earlier gets a longer term of protection, the life of the author plus 70 years. And that means you add 70 years to the year that the creator passed away, and only then does the item fall into the public domain. So Again, these are dates as of the 1st of January. And we can see that when these particular items were created. If they were created before that, then they're now in the public domain. And again, these would be rolling dates too, just like published material as time continues to move forward. So these years will roll over again in 2027. So the second way that an item can enter the public domain is that the copyright owner published the work without a copyright notice. So I mentioned that copyright law was a changing thing. So for a period of time in the 20th century, copyright owners were required to put a copyright notice on a published work to claim copyright. There are nuances, but the key window of time here is 1931 to 1977. So if you have an item published between 1931 and 1977, check it for a notice. If it doesn't have one, it's in the public domain. As a note, copyright notices generally have the word copyright or the copyright symbol followed by the name of the copyright holder. So that's something to keep in mind when you're looking for whether or not an item has a statement on it. Okay, so let's revisit one of our examples that we had at the beginning. So this ad was is from 1942. Do we consider this material to be published or unpublished under the definition of copyright? You can put it in the chat. Yes, this would be published material, right? Because it's an advertisement, so it was distributed to the public. Okay, and this was published between the years of 1931 and 1977. So we need to check for a copyright notice. Now I know that the text is a little small on here, but none of this text is a copyright statement. This is all text related to the product that they are selling. So there is not a copyright notice on this item. So based on that information, is this item protected by copyright or is it in the public domain? Yes, it is in the public domain. So a lot of you said that this would be protected by copyright. But because this does not have that required statement on it, it is in the public domain. So that's why when we're looking at these periods of time, it's important to look for certain factors. Something else published in 1942 that did have a copyright statement on it may be protected by copyright, but it may also be not. And we'll talk about that next. So the third way that something can enter the public domain is that the copyright owner has failed to renew the copyright status of a published work. So copyright renewal requirements tripped up a lot of copyright owners before the current copyright law did away with them. Failure to renew caused many works originally published between 1931 and 1963 to enter the public domain. You can pursue these, but it requires some research with the US Copyright Office. Okay, I have a question. Would the ad be protected under copyright if the magazine that is founded has a copyright notice? No, it wouldn't, because the magazine is not the creator of that advertisement. The creator of the advertisement is the company that is selling their product. So the magazine would not hold the copyright to an ad that's contained within it. Just like a magazine now doesn't own the rights to an advertisement in it, that the advertiser can publish, can submit that advertisement to be published in many different publications. And they're paying for that to appear in those magazines, but the magazine itself does not own the copyright to that advertisement. Does that make sense? Let me know if that wasn't clear. Okay, perfect. So on this slide, I do have a link, and you'll get a copy of the slides as well, that is a link to some digitized copyright renewal logs that you can search for copyright renewals in. This is going to be more tedious research, but if it's something that you really feel strongly you want to provide access to, it's worthwhile to pursue the renewal notices in these logs. Some additional information governing laws around copyright renewals. This is going to be a lot of numbers that I'm going to throw at you, but again, you'll get a copy of the notes as well in the slides. So the 1909 Act for copyright provided for two copyright terms. So the original 28-year term when you post a copyright notice, and a 28-year renewal term. But the copyright owner didn't get the second term unless he or she filed for a renewal application with the Copyright Office. If the renewal application wasn't filed on time before the 28th year expired, the work entered the public domain. In 1976, the Copyright Act was passed. Congress added 19 years to the renewal term to bring it from 28 years to 47 years. So a total of 75 years of protection. Copyrights already in their renewal term got the extra 19 years automatically. Copyrights in their initial 28-year term on December 31st, 1977, got the 47-year renewal term as long as the copyrights were renewed in their 28th year. So again, this is where looking at the renewals, looking at the publication date is going to be really important if you're pursuing digitizing items published between 1931 and 1963. So the fourth way that an item can enter the public domain is the copyright holder has dedicated it to the public domain, meaning that they waive their claim to copyright. A copyright holder can choose to do this at any point while the item is under copyright by publishing the item with a CC0 license from Creative Commons. And we will talk about Creative Commons licenses later in the presentation as well. This is an example of a Creative Commons attribution. It's not that common to see content from cultural heritage institutions dedicated to the public domain, but it is really common to see on photo sharing platforms like Flickr. This is an example from Flickr. This photograph was made available to anyone as long as they attribute the image to them and share alike. So this is a Creative Commons 3.0 license, which requires these stipulations, but it otherwise is free to use. But this is an example of what a CC license would look like. So a CC0 would just say CC0 next to it instead of three of the attribution and share alike. And then the last way that an item can enter the public domain is that it is not protected by copyright law by default. So there are certain types of work by definition that never get copyright protection. So an example of this are documents created by the federal government and its employees as part of their jobs that are not protected by copyright. And again, this only applies to federal government documents created by the United States. Other governments may impose copyright protections of their government documents. So if it's material that's coming from another country, you'll need to look at their intellectual property laws to determine whether or not you can make that available online. This also applies to state documents. And again, this will vary state to state, but in Florida, work made or received pursuant to law or ordinance or in connection with the transaction of official business by any state, regional, county, district, municipal, or other unit of government and their associated committees and divisions created or established by the laws of the government of Florida are in the public domain. Now, this applies to government entities, not state or not state colleges or universities. So state colleges and universities do still have intellectual property control over their content, because they are not government entities in the same way that like cities and counties or other state departments are. So keep that in mind as well. Universities and colleges do not fall under this category. So an institution should not claim copyright on digitized content when the original is in the public domain. This is a really important point about rights. You see a lot of folks claiming digital copyright over digital reproductions that they've made of physical items, but the goal of most digitization is to create a copy. According to copyright law, you need to be creating an alteration that meets standards for originality and creativity. This is the difference between creating a new work and slapping something on a copier. A good example of this is the artist who put a mustache on the Mona Lisa. The Mona Lisa was a public domain work because of its age. A digital copy of the Mona Lisa painting should also be labeled as in the public domain. But the mustache that the artist put on her was a commentary on art and Mona Lisa's masculinity. So it gave the artwork a new creative message, and it was therefore entitled to copyright protection, even though it was an alteration of a work in the public domain. So just keep that in mind as well. Okay, so recap. The public domain applies if the copyright has expired, the copyright owner published the work without a copyright notice, the copyright owner failed to renew the copyright status, the copyright owner deliberately places or dedicates it to the public domain using the Creative Commons zero dedication, or copyright law does not protect this type of work. So now we're going to practice a little bit more and hit some of the ones that we talked about earlier. So for this item, again, this is our election poster from 1950. Do we consider this item published? Yes. Yes, we do. Thank you. That's correct. Okay, what's the other piece of information we need to know based on the year that it was published? Does it have a copyright notice? Correct. So I understand, again, that a lot of the text on here is really small. So I've blown up what it says at the bottom for you. So this is all of the text on this item. So do we consider this a copyright notice is the next question. No, that's correct. So this was published between 1930 and 1977, and it does not have a copyright notice. So this means that this item is in the public domain. Okay, here's our letter correspondence from Sophia Hawthorne to her mother. So do we consider correspondence to be published material? No. And remember that unpublished material receives a longer protection term than published material. So what's the other piece of information that we need to know to determine whether or not this is protected by copyright? Yes, correct. When did the author die? So again, copyright for unpublished material is the life of the author plus 70 years. So we need to know when she died to determine when that 70 years expires. So you might have to do a little bit of research on Sophia Hawthorne. But Sophia Hawthorne died in the 1870s. It's also been more than 120 years since the date of this letter. So this item is in the public domain, just based on its age and the death date of the author. Does the copyright notice have to be on all material? Say an advertisement has a copyright notice in one magazine or newspaper, then it is printed in another. You know, that really, I think it just depends on the copy that you're looking at, right? So if you have, if you're digitizing a magazine and the item in that magazine doesn't have that notice, then it's not protected. There's no way for you to know where else that appeared. That's not a reasonable expectation. So I think you can just base it on what you're looking at the time. Because you're never going to know if that was published somewhere else or not. Does that make sense? Okay. Okay. We have, I think, three more, this and two more after this. So this is a pamphlet from the from 1920 for the Ward Line Mexico cruise. So is this published item? Yes, this is published because it was distributed to the public. So do we see a copyright statement on this item? No, we do not. So this item falls into the public domain. Also, this item was published in 1920. So it has also rolled into the public domain, regardless of whether or not this has a copyright statement on it. So okay. This is a drawing by Marshall Davis, an artist for the Defense Visual Information Center. So is this published? And I mean, it could have been in some publication at some point, but we're going to assume that this was unpublished. Exactly. We're not really sure if it's published or not. However, and we also don't know the year that this item was created, right? It's not part of the metadata that we had available for this item. So we're not sure when this was published or created. But we do know who created it and what their role was. So Marshall Davis is an artist for the Defense Visual Information Center. This is a drawing of a card game at Ramey Air Force Base. So this was produced by a government employee as part of his duties. So this would be in the public domain because it's a government work and therefore copyright does not apply to this item. Okay, our last item. So this is a menu from 1964 from the New York Central Railroad. Do we consider this item to be published? Yes, this item is considered published because it was distributed widely to any and all passengers on this train. So the next thing we need to look for is a copyright statement. And again, I recognize that the text is a little small. I'll read, I didn't blow up the bottom of this one for you, but I'll read what it says. It says, waste receptacles are provided in communal locations at at the end of each car, as well as in the center portion. Your cooperation in this regard will be appreciated. So, is that a copyright statement? No, that is not a copyright statement or notice. So this item is in the public domain. So hopefully some of these examples helped you understand all those different instances when something enters the public domain. So now we're going to talk about if an item is not in the public domain. So this is gonna fall under whether or not you can determine if it's in the public domain. So if you're not sure, because you're not able to answer some of these questions, or if you know for sure, and you want to weigh your risk a little bit. So what can you do if you can't determine if an item is in the public domain? You can wait to publish, or you can wait to digitize it or make it available. So again, if it was before 1930, you're in the clear. But you can wait to digitize it. You can look at the creator's death date or the creation date, or you can research the copyright status and renewal status, registration and renewal status of the item. So you might need to do some investigation. So you can just wait and see, or wait for the appropriate year to come by where you're not having to do any additional research, and then make it available at that time. Your next option is to get permission. You can do your due diligence to try to identify and locate the copyright holder and obtain permission from them. Due diligence is not a defined concept by law, but there is cases where you can exhaust all reasonable options for locating a copyright holder and document that process to show that you did your due diligence in trying to identify and locate the copyright holder to obtain that permission. So this is an example of how you can document that. So whether or not you were able to find them, what communication and correspondence you attempted to send and exchange with them, and then what the result of that was. So this is a checklist for managing digital audiovisual resources, a practical guide for librarians, and it's a good guide for the different steps you need to take to try to identify a copyright holder. Okay, so you've tried to identify the status of the item, you've documented your due diligence, but you can't find or identify the author or publisher of a work. So what do you do now? Not all is lost. So for older materials, very commonly this happens with photographs and audio recordings. It can also happen with drawings or some other creative works, sometimes anonymous literature. It may be impossible to identify and locate a copyright holder. And again, this can happen too with items that are donated to you, where you know who the donor is, but that donor may not have may not hold the copyright, right? So like if it's even if it's the person, so like let's say you have a person who's donated their correspondence, right? So they have letters that they received from various sources. Even though those letters physically belong to that person, they were sent to that person, they do not own the intellectual property of those letters because they didn't write them. So they are not legally able to transfer copyright to you. And maybe you can't identify or locate the original writer of that correspondence. So it's not just, but that also happens a lot with photographs. So with photographs, you may know who the subject of that photograph is. The person who donated it might be the subject of that photograph, but they did not take that photograph. But very often we have boxes of things that we don't know who the subject or the creator are. But these are called orphan works, where we just can't find the provenance, can't find the creator. And these items you can digitize at your institution's discretion. So consider your institution's risk comfort level and decide whether or not you're comfortable putting these more nebulous items online. Many institutions digitize orphan works. The risk is generally low when it comes to a lot of these items. And we'll also talk a little bit more about like why that is. But just a little intermission, this is like a compilation of photos of orphans. But also they are all orphan works. We do not know who the photographers are for these photographs. But we do know that the children are all orphans. So what case can be made for putting copyrighted or uncertain copyright items online? Libraries have fair use arguments that we can make. So use cases to emphasize that fair use is a set of guidelines that gets tested in court, where its boundaries are drawn on a case-by-case basis with implications for other institutions. So a lot of these rulings are not like established law because they are a case-by-case. So they are more squishy. In the notes for this, I do have a link for examples from Stanford University about fair use cases. But again, libraries are going to have more leeway here. So if fair use would be something that is being nonprofit and non-transformative, so if you're not making changes or amendments to it, and you're not making money off of it, the nature of the item is factual. You're using a small amount of the item rather than like an entire item available. And it doesn't hurt the market for the original item. So these are all cases to be made for fair use, and we often meet all of these requirements when it comes to things that we're putting online. So here's an example of a fair use case where a photographer sued an image search engine over use of her thumbnail images, and the creator lost this case. So the court determined that the use or the purpose of the search engine making these thumbnails available is that they were commercial, but but they were transformative. The nature was creative. The amount was small because they were using thumbnails instead of like high resolution images. And because of that, they didn't have a large effect on the market value of the items because people would still have to go to the photographer for the full resolution images. And a second example, directly related to libraries, is that libraries provided Google with books to scan that were protected by fair use when they used the digital scans for 3 purposes. These purposes include preservation, a full text search engine, and electronic access for disabled patrons who could not read print versions. So these 3 purposes are considered transformative from the original. And the court also did not find any evidence of financial harm and labeled the case as circular logic that any claims of lost license revenue. And this was the case of the Authors Guild versus HathiTrust that was ruled in 2012. And again, you can view more information about this case on the Stanford website on fair use. Do these fair use arguments make sense to everybody? Okay, so to recap, when you're unable to determine the copyright status of an item, you can either wait until you're sure it's in the public domain, you can get permission, and you can consider your fair use options and arguments for digitizing that item. And doing a risk assessment is going to be an important part of this process. So a lot of people in cultural heritage institutions have never encountered problems with either approach of not digitizing or digitizing items that may fall into this gray area. So here are some examples of low risk versus high risk activities. No matter what you personally think about the risk you're willing to take against challenges to fair use or your Section 108 implementation, it's important to consider what level of risk your institution is willing to support. Some publishers, for instance, are uncomfortable with any assertion of fair use rights as they wish to avoid lawsuits at all costs. Many libraries, however, are less risk averse, in part because of the generous provision of Section 108 of the Copyright Act, and the fact that there is little litigation about these sections of the Act. And because librarians in particular are protected from statutory damages in fair use cases if their fair use assessment was reasonable and made in good faith. So for instance, Section 504C of the Copyright Act provides that the court shall remit statutory damages in any case where an infringer believed and had reasonable grounds for believing that his or her use of the copyrighted works was fair use under Section 107 if the infringer was an employer agent of a nonprofit education institution, library, or archives acting within the scope of his or her employment, or whose such institution, library, or archives itself was infringed by reproducing the work in copies. Note that in order to document this type of good faith practice, librarians should not engage in large-scale digitization of in-copyright materials without engaging in careful Section 108 and fair use analysis per item. So that's something to take into consideration with your selection and your risk assessment. Not to mention the fact that state institutions may also claim sovereign immunity from lawsuits. In other words, the best case scenario for an entity suing a public library or university library for fair use or Section 108 violation would be to obtain an injunction in many cases. Nonetheless, it's important to understand the level of risk your institution is willing to bear and keep that in mind when conducting risk assessment. So what are the risks? What could happen if you decide to digitize something that is protected by copyright and make it available to the public? You could get a takedown notice. A copyright owner should provide official notice to hosts that houses the infringing material, and you must act expeditiously to remove or disable access to the alleged infringed material. Now, keep in mind a very important distinction here in language. A takedown notice is going to be a legal document that you have to comply with. And it has to come from the copyright holder or their legal representation. Now, a takedown request is not something that you have to comply with. It is simply a request. And when you get a takedown request rather than a takedown notice, you should consider legitimacy of request and either take it down or not. So this is to your discretion. So again, a notice is going to be legal, and you have to get a takedown notice before someone can sue you. So if you get a takedown notice and you don't remove the item, then you can be sued or your institution can be sued. But if you take the offending item down, then the legal risk is because you've complied with the takedown notice. But again, a takedown request is not a legal notice. So those are different things. And if you have legal counsel, you should always take those to them to make that distinction and determine your next steps. So an example of some higher risk, higher profile institutions and the amount of requests and notices that they get. HathiTrust has received less than 10 takedown notices in their existence. And the New York Public Library, which is another high profile institution, gets about 10 per year, but they're often invalid and they don't remove the material. So they assess that correspondence and determine what to do with it and the legitimacy of those items. So again, these institutions are going to be higher profile. They have a high risk tolerance, but the chances of you ever receiving a takedown notice are really small. So just keep that in mind when doing your assessment. So when appropriate, try to push the envelope, let common sense prevail, but consider digitizing orphan works and the likelihood of you ever getting some kind of notice are really small. And we're here to provide access. So just do your due diligence. Okay. And then one last item is to think through the likely sources of pushback when assessing orphan works. So content related to public figures that are produced by or about public figures, and then also be mindful of privacy issues that may come with digitizing certain materials, like intimate family portraits, or things or items that pertain to protected populations like children and inmates. So these are not copyright considerations, but there are other legal concerns that may come with certain types of material. So just keep those in mind. Okay, so determine the right status of the work, digitize it, and the last step that we're going to talk about is clearly and concisely stating the copyright status of items in the metadata. So this is the right statement or the rights status and whether and how the item can be used. So we're going to do a little quiz again and determine whether or not you can use the following images on your website. So based on the metadata provided for this item, can you use this on your website? I would say that based on the information provided by the institution, it's not clear whether or not you can use this on your website. This is because they provide you with contact information, but they don't actually tell you what the copyright status of the item is or what users can and can't do with it. So this creates a situation where someone has to man a permissions desk and field requests for this item. So it has not been clearly communicated. Well, we're looking at a thumbnail. We're not looking at the full item. So, and you also know that about copyright, but does the user know that about copyright? That it has to have a statement on it. So that's something to keep in mind is how do we make it easier for our users to determine what they can and can't do with this? So approach this from a lens of a user. So looking at this item, is this something that you can use on your website? No, that's correct. And this is because we've clearly communicated that this item is under copyright by JP Morgan Chase, who manages the estate of the creator. So while it's not as open because it is under copyright, it is clear what the copyright status is, and we know who holds the copyright, so the user can contact that person or that organization in order to get permission to reuse the item. So what about this item? Yes, correct. So this item is clearly labeled. It is clearly labeled that it is still under copyright by the creator, but has been licensed. So it can be reused with certain stipulations. So this is not a CC0 license, but it is a Creative Commons license that allows for non-commercial use and no derivatives. So there are some restrictions, but it is free to reuse with these stipulations. So this is a very clear statement. So here we understand that right statements communicate the legal status of an item. And reuse statements communicate how to responsibly use an item. So best practice for your metadata creation is to include reuse statements with a right statement whenever possible. And you can repeat the field for each of these statements so that your users understand what they can do with the content on and offline. So one of the ways that we can approach this is by using rightstatements.org statements. This is a project that was created in collaboration between the Digital Public Library of America and Europeana. These are designed specifically for cultural heritage institutions to cover the most common situations encountered for the legal copyright status. They're simple and flexible to use. Informational statements about copyright status. They're not licenses. That's what Creative Commons is for. They only describe the copyright status, but not other legal restrictions like privacy. And they are both human and machine readable. They have a human readable text, but also a URI that can be added to your metadata to be machine readable and used for filtering and other machine readable functions. So the rights statements provided by rightstatements.org are tools to help provide standardization and consistency. They're meant to be simple and flexible and cover a wide variety of use cases. They're intended to be informational and are not proof of legal copyright status. Also, they're not licenses, and they only address the copyright status of an item and don't cover other rights that may exist. So why would you want to use some of these standardized statements? So several years ago, there was a data set pulled from the Digital Public Library of America of 1.3 million records. This is a sample. There's over 50 million items in DPLA. And in this small sample of 1.3 million records, they found 26,000 different rights statements. So that's a lot of different statements to convey what should be pretty straightforward information. So this project is really aimed at making it easier for cultural heritage institutions to apply rights statements and to make it easier for users to understand the rights status of a material. So again, we're going to look at some examples of some of these unique rights statements. Now, these are old. We're not picking on anybody. A lot of these have been updated, but these are some examples of why some of this standardization work was undertaken. So this is a really long one, and I've blown it up a little bit so you can actually read it here. But this is a really long statement that claims copyright and has a lot of other information in it. This is really dense, and a user is probably not going to know what to do with this statement. The other thing to note about the statement is, again, the first sentence says that it's held under copyright of Brigham Young University. But if we look at the publication date of this item, it says 1892. So this item falls under the public domain just because of its age. So this is clearly a statement that they've just put on everything that they've put on their repository, right? So they haven't done a careful analysis. They've just slapped a copyright statement on everything that they've put in here, which is not the approach that you want to take. It makes it harder for you and for users because, again, then you have to man a permissions desk, you have to answer and do research, whereas if you're making this statement clear on the item, the user knows what to do with it, and you don't have to do any research or additional interaction to make that clear to the patron. So this is another example. It's a lot briefer, right? So this image cannot be copied or reproduced without the written permission of the submitting institution. It's also very clear. However, because this is a free text statement and doesn't have a URI, it can't really be used for filtering. So if you want to add a filter to your repository or an aggregator has a filter that allows for users to search by items that are in copyright or free to use, you can't do that with these free text statements. So again, a standardized statement here would also be clear, but allow for that machine readable capability to be utilized. This is another example. So this statement says Smithsonian American Art Museum, museum purchase. So this is not rights information. This is provenance information, right? So does this really belong in the rights field, or does it belong somewhere else? And how are we communicating the status of this item to users? This one does indicate that the item is still in copyright, and then it goes on to provide information about how to get permission to use the image. This is helpful information, but it doesn't necessarily belong in the rights field. So this extra information, so in the rights field, you really want to be concise. You want to get across the copyright status of the item. And then this information can belong on a different page on your repository that gives users all of the information they need to contact you to get permission for things. So you can just have that. And then it's easier to update too. So sometimes this information changes, who they need to contact, or where they need to write to, or if there's an email address, and having all of that information in a centralized location that can be easily updated and easily accessed is better practice than stuffing all of that information in individual elements like this. And here we have an example of a very simple, very straightforward right statement. This is in the public domain, but again, it doesn't have that URI. You can't, it's not machine readable. So this is a good example of good best practice if you don't have machine readable capability in your repository. But if you're thinking about sharing that anywhere else, you may consider using the right statements URIs here. And then here's an example of a rightstatements.org statement in practice. And you can see here where this repository or this platform is using that machine readable URI to populate an image that is easily identifiable for users and takes you to the rightstatements.org page for more information as well on what that right statement means. These are the 12 right statements that are available on rightstatements.org for use. The statements provide a minimum baseline standard for organizations in the United States and the European Union. Other countries around the world are actively joining this project, and they keep a list of all the countries that use these statements or that have incorporated these statements on the rightstatements.org website. The three basic categories of these statements are in copyright, no copyright, and other. Those three categories are reflected in the icons that you see next to each one. You may notice that there's no statement for public domain. The closest equivalent is no copyright United States. This was intentional based. This was an intentional decision because the statements are intended for only materials that could potentially have a global audience. While copyright status varies from country to country, for example, an item that has passed into the public domain in the US may still be protected under copyright in Great Britain. So under the guidelines, public domain should only be asserted when an item is known to be free of copyright around the world. And in those cases, the Creative Commons public domain mark can be used. So I want to note that for the rest of this presentation, when I mention public domain, I mean that the item is in the public domain in the United States. And the Society of American Archivists has guidelines on how to implement rightstatements.org statements, which have good information about when to use each statement, especially for unpublished materials, and they go into more detail about the public domain. And there's a link to the SAA guidelines at the end of the presentation. So of the 12 statements, these are the 6 that you're most likely going to be using. And I would discourage the use of copyright undetermined, but there may be cases where you've looked for that copyright holder. But in that case, you want to say no copyright. And we really don't want you to use copyright not evaluated. If you haven't evaluated the copyright status of an item, it probably shouldn't be on your repository. And then this is an example of what the additional information that's provided on rightstatements.org when you click on that URI. So again, why would you want to implement this? It provides consistent right statements for users, a clear framework to approach copyright for digital projects, and provides standardization that is both human and machine readable. So let's talk really quickly about Creative Commons. Creative Commons develops, supports, and stewards legal and technical infrastructure that maximizes digital creativity, sharing, and innovation. It works within the copyright law to protect works and provide access to content that might otherwise be inaccessible for decades. Creative Commons licenses are for copyrighted works only. You can't apply copyright license or CC license to a work unless you're doing so in conversation with the copyright holder, but they do allow works under copyright to be more open. That example of the Leslie Jones photograph, they agreed to the terms of the Creative Commons license for online display with the Boston Public Library as part of an agreement with about his work. So that was done in collaboration with the estate, and they agreed to those terms. And these are applicable globally, and really give creators control over how their content is used and licensed. So here's a key to decode the alphabet soup of Creative Commons. So CC stands for Creative Commons, BY stands for attribution, SA stands for share alike, NC stands for non-commercial, ND means no derivatives, and 0 means that the copyright holder has dedicated the work to the public domain. And this is what those look like. And this goes from most open to least open. And this is what it looks like on the Creative Commons website. And this is an example of that Creative Commons licensing practice. So this license tells us that we can use this non-commercially if we attribute and any derivatives also have the same license, so that share alike. This is an example where a user can use it non-commercially if they attribute and don't make derivatives. CC BY and C and D. Okay. So there's no one right way to assess copyright and implement standardized statements. Everyone's process is going to be a little bit different based on your digital content, the systems that you're using, and the resources that you have available. So you need to consider your risk. What's your institution's risk tolerance? There's often a lot of gray areas in copyright, especially around orphan works, or where you just don't have enough information to make a firm decision. In these cases, is your institution more conservative, or is it more willing to accept a bit more risk to make materials available online? You may decide that there is not much risk involved with some materials, but that some more high-profile or more recent materials may warrant closer attention when you're determining copyright status. Ideally, you consider risk assessment when you're planning digital projects and selecting what to digitize, but it's good to revisit. When you need to know your current rights landscape, so for existing digital collections, does your digital content already have rights information in the item level metadata? If so, what does that look like? If not, is rights information documented somewhere else? Are there folks you can talk to who have background information about copyright for the materials? So do you have access to the donor or to the creator? Once you know what you're working with, you can develop a plan. So you can determine who is going to do the work, how much time they can devote to the project. You can see what training you might need, and you can start thinking about workflows and how you might address questions that come up. Then you're ready to start the actual assessment. Depending on your digital content, this could be more or less complicated. For example, if you have a digital collection that consists entirely of images by a single photographer who gave you permission to put the materials online, then assigning a rights statement is pretty straightforward because you can assign one rights statement to all of the materials and you're good to go. But if your digital collection is a manuscript collection with letters, photos, and documents by a whole bunch of different creators, then it could be much more complicated because they all might have a different copyright status and you have to assess them one by one. So depending on the number of items that you have to review, the amount of time that you have, you may not have time to do a lot of in-depth research to figure out the status of every item in your collection. If you're working on legacy digital content, it can be really helpful to review your metadata for useful information, like the date of publication for published materials, or the death date of the creator for unpublished materials. For archival materials, it's also helpful to check the deeds of gift for rights information. Maybe the donor gave copyright to your institution and it's documented in the deed of gift. Sometimes you can also find useful information about when a creator passed away or when a company went out of business. You may not always find the information that you're looking for, but the deeds of gift can definitely enrich your contextual understanding of the materials, so they're definitely worth checking. And one thing you want to make sure to do is to document your decisions and the rationale behind your decisions. That way, if questions come up in the future, you can look back and see why you made a particular decision, and it can also be helpful to know any questions that you have. So as you go through the project, you may notice patterns and find things that you need to do further research on. Once you evaluate your digital content and determine the appropriate rights statement for each item, you want to include the rights information in your metadata. Workflows here can vary a lot depending on your system, but in most cases, I think you'll find that spreadsheets are your friend. And that way you can sort by date, you can sort by creator, you can group similar items together, and you can document your decisions and questions all in your spreadsheets. So those are all of the steps that we talked about today. We have a question, how would you define derivatives in this legal context? So when we're talking about Creative Commons, so derivatives are like if you're republishing something, right? So like not necessarily like using it in so like if you're like republishing it in some way. So like rather than so like this one, we're using this non-commercially. I'm not using this as like a publication on its own. I'm using it as part of a presentation as an example, right? So yeah, and digitization is not a derivative. Is not a derivative. Yeah. Okay. If you're working to upload a large group of items owned by an institution, what would be the best way to ask the institution for permission? Would you list the items individually or group them together? Also, how much information should you include for each item in your request? So I think that depends on how you obtained those items, right? Did that institution donate them to you? Do you have a deed of gift? Um, I think that it would be best to have a conversation with that institution about how much information they want. So I guess in your initial request, you could let them know that you're interested in digitizing these materials for research purposes or for educational use. And if they want more information on the individual items, then you can provide that at that time, but I wouldn't do it in my initial communication with them. But it also really depends on how you obtained those materials. Um, so that would be like a, a longer conversation with that institution. So yes, and again, there are multiple resource slides. I will be sharing this slide deck with you, and it will be available in the recording as well. So these are statements for rightstatements.org. These are some general copyright resources. Um, this first one is really helpful. It's gonna have lists for all of those different time periods, as well as the different rules for published versus unpublished material. So that's a really good one. Um, and then some additional resources around fair use and some additional tools. Um, okay. Do we have any other questions?